house. Let's talk McCloskey's, because this is another one where I say projection. It would seem the prosecutors are accusing the victims of doing exactly that which the prosecutors themselves are doing. For those of you who don't know, I mean, I'm sure we all know McCloskey's brandished the firearms during They held their firearms during a protest where they broke onto private streets or, in front of their house, saying, "We're going to take your house. That's going to be my room. We're going to burn down your business," whatever. They get indicted on gun charges. It turns out that the investigators, in the course of the investigation, disassembled and reassembled Ms. McCloskey's pistol because it wasn't functional. It couldn't be fired. And then it test fired properly. They brought charges for whatever it was, brandishing a firearm, exhibiting a firearm in an angry or threatening manner, an arm that is readily capable of lethal use. They were then rebrought on additional indictment, which consisted of tampering with evidence. Now, not to say that I trust everything Mark McCloskey is saying on Twitter, because I don't, and it's not to say I don't trust him. I don't trust anybody. He's giving us one part of the story. He doesn't know what it is. He doesn't know what he's being accused of tampering. Whatever. But the bottom line is they seem to have been brought up on new charges on tampering with evidence. The theory is that they tampered with the pistol to render it inoperable before it was seized. For the first question I had, because there's two lawyers in here for the McCloskeys. One saying that he confirms that the weapon, the pistol, I don't mean to say weapon in a judgmental way, it's a force of habit, the firearm had been rendered inoperable for a trial. He had it briefly in his possession before it was seized. Did the investigators seize it from the lawyer or from Patricia McCloskey? Or do we know?
We don't know. And the big problem with this charge out of the gate, aside from evidentiary proof issues, and I think, and like what you identify, the projection going on, is I don't think they can be charged with tampering. Because to give the tampering laws in Missouri, like all obstruction laws, require that you tamper with something that is the subject of an ongoing proceeding. And if the allegation is that they tampered with the gun before the gun was seized, that cannot, as a matter of law, be tampering. That you can only tamper with something that's part of an already official proceeding. In other words, you receive a subpoena, like you do what Hillary Clinton's people did. You receive a subpoena, and then you go delete after you get the subpoena. That would be the subject of tampering. Or in the case of a FOIA request, if you're a government agent, then that could be also tampering. So usually tampering is something government agents do. It's not something they accuse individuals of doing, because it's very hard for an individual to be in custody of something that's evidence in a proceeding, because almost always the government's going to have that. So it appears that you're right. That's not only projection, but it's illegal. It's not a crime, what they are alleging, even if what they were alleging was factually true, for which there's doubt.
Well, if I push back there, because I'm thinking, I know, the argument is going to be they weren't under investigation, they had no reason to believe, et cetera, et cetera. If someone goes out and knowingly breaks that article, subsection 4 of whatever the provision is, well, their best defense is like, holy crap, I just broke the law. I'm going to go home, make the gun inoperable, basically destroy the evidence, even though they're not under investigation, but knowing that it's coming. So I would imagine there has to be some caveat or provision. That's my thought, because it's very easy to go commit a crime, know that there's going to be an investigation, and then destroy the evidence and say, well, I can't be accused of tampering with evidence because there was no investigation. I just destroyed it.
Indeed. So 2 federal cases on this that are the best. One is Aguilar, where a federal judge lied to FBI agents while a grand jury case was pending. The United States Supreme Court determined that because he couldn't know that grand jury proceeding existed, that he could not be prosecuted for obstructing a grand jury, even though it was incontrovertible that he lied. Now, my favorite is Arthur Anderson, 9-0, unanimous decision. Goes back to goes back to the same people who were going after Flynn, part of Mueller's team, Weissman and other guys who came up with theories like these Missouri prosecutors are. So Arthur Anderson knows that there's probably an Enron investigation coming, but they don't have the subpoena, hasn't come in the mail yet. and so what does Arthur Anderson do? Shred, delete, shred. It's like that's from the movie, the Al Pacino movie, where the devil is the lawyer. And there's a whole scene where they're shredding, and Keanu Reeves is was
it the Devil's Own?
The Devil's Advocate, I think.
Devil's Advocate.
So so we got our second cinematic reference in there.
Just so long as it wasn't Angel Heart. That's
great movie, great movie. That's a great third cinematic reference. The Lou Cipher has come to town to help you out. So but what did the Supreme Court say? 9-0, because there was no evidence in someone's possession or custody. You could not be prosecuted for obstructing an SEC investigation, even though they received a subpoena the next day after they destroyed everything. The reason is this. We don't want to make individuals agents of the government. So it happens a lot in IRS context. So like people destroy certain things and the IRS wants to call it a crime. And the courts have consistently ruled it's not Americans' duty or job to make the IRS's job easier. You can't lie to an agent in the middle of an investigation. You can't after you've been summoned or after you've been subpoenaed or after a search warrant, you can't destroy evidence at that juncture. But before that, a proceeding is happening, and I guarantee the McCloskeys would know this as lawyers, most likely. You can do whatever you want, and you have no obligation to go around making the evidence against you stronger. You just don't. So that's where I think the tampering charge is legally insufficient as a matter of law, because there was no official proceeding pending at the time in which I believe they're alleging that tampering took place. Now, there's the second problem of the factual issue of proving that any tampering ever took place in the first place. I mean, it very well may be the case that she went out there with a gun that was inoperable just to show off. I mean, it was a tiny little gun. It's not like she was actually going to shoot it. He had the AR. He had the big gun. So, if any gun was going off, it's going to be his. She was just reinforcing it with her little gun. But it turns out there was a reason for the gun being inoperable, which is what the lawyer testified to, that it was previously used as a prop. Because the prosecutor's office assumption was this gun had to have been operable. We had to go make it back operable. So it must be the case that their only reason for a gun, for her to possess it and brandish it, is that she later made it inoperable. That still doesn't make it a crime under the official proceeding. They call it the nexus requirement. There has to be a nexus between what you did with the evidence and an official pending proceeding. Without that, no obstruction, because we don't want the government to convert individuals into confessors against themselves, into investigators against themselves, into being agents of the state.
Okay, that's interesting. And then the question, I mean, so people were asking, why would they have only rendered inoperable the pistol and not the AR? And my theory was, when the incident occurred, I remember people saying, look at her, what do they call it? Trigger control. Like, she has her finger on the trigger. It's dangerous. So my theory might have been that they might have felt there was more exposure for the way she was handling the pistol as opposed to the way he was handling the AR. But knowing this Anderson rule now, there goes one of my theories, that they could have it could have been operational. They could have rendered it inoperable, and then they got it seized, knowing that the investigation was coming. Okay, that's very interesting. But what have now? I'm knowing what decision did not come to in the grand jury in Breonna Taylor. What evidence was presented to the grand jury in this case? Like, how does it happen?
Clearly selective evidence. It's because grand juries. Now, for folks that don't know, grand juries are constitutional under the federal system. They're under the Fifth Amendment to the U.S. Constitution. They're usually constitutional in the states that have them. Not all states have grand juries, but in those that have them, and the goal of a grand jury was supposed to be an independent check on the entire criminal investigatory and prosecutorial process. That grand juries would decide whom to investigate. The grand juries would decide whom to prosecute, particularly when it reached that stage. You would have police involved in the initial investigation, but grand juries would be the check on the whole rest. And the reason why they're secret is so that information that is private doesn't get out to the public that was needed to be investigated in the grand jury context. Instead, that's been completely abused. Prosecutors have hijacked it. Judges filter out grand jurors so that they're made of establishment types. If you go get a voir dire of a grand jury, see what a judge really tells them. See who they filter out of that grand jury process. They make sure that the wrong people don't show up in that grand jury. And then make sure that people don't ask questions, don't second guess. You have all these rights as a grand juror. Almost no one knows that. Now they're told the generic, you can ask questions, etc., but they're not given real power to say, hey, you run this show, not us. We're here working for you. You're not here working for us. And any question you want, if you want to subpoena evidence, we'll go out there and subpoena it for you. You want us to go subpoena a witness, we'll subpoena a witness for you. You want to go look at something, we'll bring it in for you, because that's your right, your power. And if you think somebody committed a crime, you just ask us what the law is, we'll let you know what it is, and then you decide whether to charge them. That's how it's supposed to work. It used to work that way at the beginning of the country. It's been totally hijacked by prosecutors. So now they're just rubber stamps for prosecutors. And it's very rare you see an independent grand jury in America today. And so they did what the prosecutors asked them to do. I have no doubt.
And we had discussed this earlier as to what rights and remedies the McCloskeys might have. These are federal charges, so there could, in theory, be a pardon.
I think these are still state charges.
So the governor, someone could give them a pardon.
Oh yeah, the governor already said pardon them across the board, so they'll never serve any jail time.
And now, do they have any? What does it take for the prosecution or the circuit attorney? What does it take for the DA to get investigated in this?
The DA can be investigated by the Attorney General, and the Attorney General is already intervening in the case if he wants to. In addition, I can guarantee if the politics was reversed, it would be happening already. If there was a Democratic Attorney General and a Republican DA doing this, they'd already be under investigation. The Republicans all try to do things proper, and consequently they get rolled over. They keep wanting to fight by the Marquess of Queensberry rules when they're inside a gutter, and good luck with that. But that could happen, and then the state bar could investigate. But again, like the state bar, all Democratic people generally. So I've never seen the state bar go after a government. They generally never go after prosecutors, period. And going after a Democratic prosecutor, going after an African-American Democratic prosecutor, ain't happening.